The roots of legal positivism. Legal positivism is an approach to law which focuses on the question, is this a valid law or not? And it does so by concentrating on whether the law has come from the right source. The roots of legal positivism go back to the philosophers Hobbes, Bentham, and Austin. The preeminent thinker in 20th century legal positivism in the English-speaking world was H.L.A Hart. Thomas Hobbes. Hobbes was a 17th century philosopher whose masterwork, Leviathan, was written during the English Civil War. Hobbes thought that law depended on sovereignty, on the clear identification of the person or body who was the ultimate legal authority in a particular territory. The main cause of the English Civil War, in his opinion, was a fight about whether the king or parliament was sovereign. For Hobbes, in the end, law boils down to power. Like his contemporary John Locke, Hobbes imagined how human beings would interact in a state of nature. Where Locke was quite positive about human interactions in a world without any centralized political authority, Hobbes memorably claimed that such life would be solitary, poor, nasty, brutish, and short. Afraid of uncontrolled violence, individuals would rationally decide to appoint a sovereign ruler. That sovereign ruler could be an individual, a king, or could be a body, a parliament, or a congress. But through this social contract, the sovereign would be given authority by the people. Henceforth, the law would simply be whatever the sovereign decided. In order to identify something as law, you simply have to identify whether it is a command made by the sovereign or whether it's made by someone to whom the sovereign has delegated part of his power. Now, Hobbes scholars argue about whether or not Hobbes's theory has any room for any meaningful constraints on the commands of the sovereign. What is telling, however, is that Hobbes calls the sovereign, or the state apparatus of which the sovereign is head, Leviathan, and refers to it as a mortal god. Law is, for Hobbes, essentially the top-down exercise of power. The content of the law is wholly or largely irrelevant. This leads to a sources theory of law, whereby in order to identify whether something is or is not a valid law, you have to establish its pedigree to show that it can be traced back to a de jure exercise of power. The relationship of sheer power between subjects and their sovereign is a reflection in Hobbes's philosophy of the relationship between humans and gods. He wrote, "The right of nature, whereby God reigneth over men and punisheth those that break his laws, is to be derived not from his creating them, as if he required obedience as of gratitude for his benefits, but from his irresistible power." In fact, though Hobbes quotes frequently from the Bible and names Leviathan after a biblical sea monster, he is widely regarded as having been an atheist. For Hobbes, unlike his contemporary Locke, one of the rights individuals cede to their sovereign is the right to tell them how to worship God. Hobbes's Christianity is therefore, on his own logic, simply him being obedient to the commands of his sovereign, rather than an expression of genuine faith. Now, legal positivism claims that it is simply interested in the question of how to identify valid laws, and thinks that whether those laws are morally good or bad is an entirely separate question. However, Amanda Perot-Cecine argues that Hobbes and all other consistent legal positivists are committed to what she calls metaphysical positivism, that is, to the rejection of any philosophical notion of moral authority. Laws bind simply because they are made by the sovereign, not because they reflect or promote any positive good. The good isn't something that's given to us. The good is simply to be decided upon by what the sovereign chooses and what we as individuals choose. Jeremy Bentham. William Blackstone, whose commentaries on the laws of England formed the definitive guide to the common law of England, taught his students that Christianity is part of the laws of England, and that although God has made human beings with free will, there are certain immutable laws of human nature whereby free will is in some degree regulated and restrained, and that God gave the faculty of reason to discover the purport of those laws. Now, Blackstone here is maintaining a tradition of natural law, which taught that God had given laws to human beings in nature and in the Bible, and that it was the task of human judges and legislators to reflect on those God-given laws and to decide cases and make laws in the light of those God-given laws. Jeremy Bentham was one of Blackstone's students. He listened to Blackstone's arguments and rejected Blackstone's position. Bentham thought that talk of natural law and natural rights was a waste of breath because there is no way of rationally establishing what the content of natural law and natural rights might be. He famously described rights as nonsense and the idea of natural rights as nonsense on stilts. Bentham believed that human rationality alone could decide what was right and what was wrong, and what should be legal and illegal, and that appeals to natural law and to natural rights were useless. He argued that an alternative criterion for rational decision-making about legal rules was required. And so he developed the philosophy of utilitarianism, whose fundamental maxim is that the greatest happiness of the greatest number is the measure of right and wrong. The aim of good law, therefore, is to maximize happiness. This should be the criterion by which legislators and judges decide how to make law. Utilitarianism's theory of ethics is consequentialist. Right and wrong are, for the utilitarian, determined by considering the likely consequences of one's actions. So the question of deciding whether or not I should keep my promise is to be resolved by thinking solely about the balance of harms and benefits which will result from doing so, rather than seeing the promise itself as the determining factor. Therefore, in order to get people to obey the law, you need sanctions. Now, Bentham saw sanctions as central to an account of law. If individuals act according to the principles of utilitarianism, or even if they are simply selfish, they may have an incentive to break the rules on occasion. In order to overcome this incentive, the realistic threat of unfortunate consequences is necessary so that it will always be preferable for the individual to obey the law. The imposition of sanctions achieves a convergence between general welfare and individual self-interest. Bentham was a law reformer. With considerable justification, he thought that much of the legislation in England was not good and did not promote the greatest happiness of the greatest number. He also thought that the common law was confusing and that people would be much better off with clearly codified laws. So he set out to rationalize and reform criminal law, prisons, the poor law, the judiciary, and contract law. It may not surprise you to learn that this task proved to be too great for one individual. Bentham was, like Hobbes, an atheist. After his death, he was mummified, and his mummified body was put on display at University College London. Bentham saw law as it is, based on purely on power, but argued that law as it ought to be should be governed by his consequentialist logic. Because Bentham's utilitarianism had no room for rights or any other a priori restrictions on the content of law, Amanda Perot-Sassoon saw him as yet another legal positivist who denied moral authority. At its most extreme, Bentham's legal positivism provides no defense to the Jew or Roma whose extermination is viewed by Nazi rulers as promoting the greatest happiness of the greatest number. John Austin. Bentham was mentor to John Austin, who was professor of jurisprudence at University College London from 1827 to 1834. John Austin wrote, "Law is set by political superiors to political inferiors. Law is a rule laid down for the guidance of an intelligent being by an intelligent being having power over him. And every law is a command." John Austin argued that laws are the commands of a sovereign, and that a sovereign has authority because and insofar as the sovereign's commands are habitually obeyed by most of society. So law could be identified simply by a factual inquiry into the identity of the sovereign, and then a factual inquiry into the rules made by the sovereign. Austin was absolutely rigorous in maintaining a very strict distinction between is and ought. He wrote this: "The existence of a law is one thing, its merits or demerits are another thing. Whether a law be is one inquiry, whether it ought to be, whether it agree with the given or assumed test is another and distinct inquiry." So Austin thought there should be two different subjects, one exploring what the law is and another exploring what the law ought to be. Unlike Hobbes and Bentham, John Austin was a Christian. Austin squared his utilitarianism and his Christianity as follows. Divine law is, for John Austin, consisting of two parts: revealed and expressed divine law and unrevealed or tacit divine law. The divine laws which are revealed are express commands signified to men through the medium of human language, and uttered by God directly or by servants to whom he sends to announce them. These commands are mostly in the form of general rules, and the Ten Commandments would be a clear example of this kind of express divine command. In Austin's view, the tacit divine law, which is a direct application when God has given no express commands, well, that's the utility principle. Austin reasons that the goodness of God is boundless and impartial, that God designs the greatest happiness of all his sentient creatures, and therefore, from the probable effects of our actions on the greatest happiness of all, or from the tendencies of human action to increase or decrease that aggregate, we may infer the laws which God has given, but has not expressed or revealed. Let's sum this up. If you're deciding what to do, the first thing to do is to ask, has God issued an express command? For example, do not steal. If God has issued an express command, then it's clear that you should not steal. You don't have to go through the process of working out for yourself whether stealing would or would not contribute to the greatest happiness of the greatest number. God's express command has given you a shortcut. It's given you a definitive answer that stealing would not be utility enhancing. But if God has not issued an express command, then you're free to use your own reasoning to assess the consequence of your actions. But you do this not on an ad hoc basis. Would it be good for me if I did this? But you do so on the basis of what the likely consequences would be if actions of that class were generally done or generally not done. What would be the probable effect on general happiness or the general good? Now, because Austin is drawing a stark distinction between law as it is and law as it ought to be, Austin asserts that to say that a human law which conflicts with the law of God is therefore not binding or not valid is to talk stark nonsense. In this one sentence, Austin dismisses the idea that a conflict between a positive law and divine or natural law could result in the positive law losing its status as a valid law. He also stresses that positive laws in conflict with divine or natural law remain binding, by which he means not that they continue to generate genuine moral obligations of obedience, but that subjects who defy those laws will be subjected to punishment. There are two big questions about Austin's approach to legal positivism. First, is it coherent? Does the mix of general rules given by God and the utility principle translate when applied to laws made by human authorities? And second, does it explain why laws create an obligation of obedience? The worry is that the commands issued by Austin's sovereign are indistinguishable from the demands made by a man pointing a gun at you and ordering you to do something. H.L.A Hart. H.L.A Hart is the preeminent figure in 20th century English-speaking legal positivism. He defined legal positivism as the simple contention that it is in no sense a necessary truth that laws reproduce or satisfy certain demands of morality, though in fact they have often done so. This definition of legal positivism means that identifying something as a law has no or little relevance to the question of whether there is a moral obligation to obey that law. And Hart thought that this distinction between what is a valid law and whether or not it's a good law or not was helpful for clear thinking. In particular, he thought it would be helpful to persuade people that there isn't a presumptive obligation to obey the law. As we've seen, before Hart, legal positivism, with its origins in Hobbes' Leviathan and its classical expression by John Austin, defined law in terms of the commands of the sovereign. The only person whose purposes and thoughts were relevant in order to identify something as law was the sovereign. Now, Hart nuances that position in two ways. First, Hart accepts that all human beings want to survive, and therefore there is a minimum necessary content to law, a pretty minimum natural law. Second, Hart wants to draw a distinction between orders issued by a gunman and the commands given by a sovereign. He wants to answer that second problem in Austin's thought. Commands given by a sovereign are laws, according to Hart, if they are regarded by the officials in a legal system as authoritative. But Hart never actually explains how we identify who these officials are. Now, Lonnel Fuller was not convinced that Hart's version of legal positivism captured the nature of law. He was impressed by the Soviet scholar Evgeny Pashushkin, who dismissed legal positivism on the basis that if a neat chain of command were the most significant quality of law, then we should regard the military as the archetypal expression of juristic order. Like Bentham, Hart coupled his legal positivism with a commitment to utilitarianism and to law reform, arguing in favor of many of the liberalizing laws in England in the 1960s. Legal positivism may not logically entail a rejection of rights and of natural law, but as the thinkers in this video show, they're often found together in the theory of the major thinkers whose ideas provide the roots of legal positivism.